Okay, welcome to this Youth Week webinar, I Want to Divorce My Parents. We would like to begin by acknowledging the traditional owners of the lands from which we are broadcasting today. I'm broadcasting from the land of the Widjabul-Waible people of the Bundjalung Nation. We pay our respects to elders of this land, both past, present and emerging, and we extend that respect to any Aboriginal and Torres Strait Islander people joining us today or watching the recording of this webinar. My name's Bridget Barker and I work in the Community Legal Education branch at Legal Aid New South Wales. This is a 1-hour webinar, and as I said, we will answer questions at the end of the webinar. You will receive an evaluation survey after the webinar, and we really do value your feedback. You'll also receive an email with information about resources that are referred to in the webinar today. We will be referring to the law in New South Wales in today's webinar. If you are joining us from another state, the laws in your state and any available services may differ. Now to hand over to our panel, I'd like to welcome Jane Sanders from the Shopfront Youth Legal Centre and Kate Duffy from the Children's Civil Law Service at Legal Aid New South Wales. Thank you, Jane and Kate.
Great, thank you, Bridget. I also would like to acknowledge that I am on Gadigal land today and pay my respects. And I believe, Jane, you're probably on Gadigal land?
I'm also on Gadigal land, so I'd like to acknowledge the traditional owners and pay my respect to their elders, past and present. Thanks, Kate.
So we wanted to start just by acknowledging our the title of the webinar, which is I Want to Divorce My Parents. And this came from a real life advice clinic or call from a young person who called up one time when I was working at a community legal centre saying I want to divorce my dad, and that always just stuck with me. But there is no such thing as divorcing your parents. So I just wanted to flag that is not actually a legal thing that one can do. Today we're going to be talking about how young people can become independent from their parents, and we're going to touch on some different legal issues. We're going to have some interactive polls throughout the session, and we're going to focus on a case study as well. So maybe we'll launch the first poll. So Bridget, if you want to move on. Oh, there we go. Great. So the first poll is about moving out. When can I move out of my parents' or guardian's place? Is it 17, 16, 15, or it depends? Hopefully you can just click on the poll. And we should have some answers soon. Great, yes, so we've got some 17, some 16, 1 15, but the majority says it depends, and that would be the correct answer. It definitely does depend. The law does not set a minimum age for leaving home. As many of you who work with young people know, particularly if you work in youth services or homelessness services, you definitely know that young people do leave home. I think young people vote with their feet. Isn't that right, Jane?
Yes, it is. I think we should say, though, that just because a young person can legally leave home at any age, it doesn't mean that they're independent of their parents for all purposes. It doesn't mean that they can, that they're treated like an adult in all areas of life. It doesn't mean that they can make important decisions without the consent of their parents. So depending on what age a young person leaves home, if they are very young, then of course there will usually be child protection involvement. They might be returned home if the DCJ thinks that it's safe for them to go back home, or they might be put in care, could be kinship care, or foster care or other forms of out-of-home care. And there could be a care order made placing the young person in the care of the minister or the Director General, I think it's the minister formally, until the age of 18. But the older you are when you leave home, if you're 15, 16, 17, the less likely you are to be placed in any kind of formal care. So your parents, guardian, still have legally still have parental responsibility for you. And there are certain decisions in life which you may not be able to make without the consent of your parents, and you can be in a bit of legal limbo.
Yeah, absolutely. Obviously very different if a 12-year-old is on the streets compared to a 17-year-old leaving home, and very different situations there. Yes. All right. What's the next slide? Oh, great. Our case study. So let's talk about Ruby. So Ruby's 15 and she's walking into your service asking if she can have a feed. Ruby looks pale and tired. She's carrying a small backpack that has some clothes falling out of it. You notice some bruises on her arms and red marks around her wrists. You start talking to Ruby and find out she slept rough last night. Ruby says she caught the train to Sydney yesterday from Wagga Wagga after having a fight with her mum. Ruby says she's not going back home. She hates her mum's new boyfriend, doesn't want to live there anymore. So I guess the first question is, Ruby doesn't want to return home. Is she allowed to leave home, Jane?
Well, yes.
Yeah.
She thinks it's not safe at home. She's 15. She's an age when she can express her views. She can make her own decisions about things. But she's still under 16. So if you're a worker in a youth service, you would probably understand that you're a mandatory reporter. If you believe that she's at risk of serious harm, then you would be making a report to DCJ. Also, if you were now she's walked into your service asking for a feed, not for accommodation, but if you were a refuge, running a refuge or a youth accommodation service, the Act, the Children and Young Persons Care and Protection Act, also requires you to report to DCJ if you're providing accommodation for someone under 16 who's away from home without parental permission. Now, that doesn't apply if Ruby had gone to her auntie's place or her best friend's mum and dad or whatever. They don't have to notify the department. But if you are a service providing accommodation for homeless young people under 16, you would also have to report that. But yeah, Ruby can, I don't think anyone's going to make her go home.
No, I think the likely thing would be she would engage with the youth service and into some homelessness service and things like that. Yeah, the police unlikely to force her to go back because she says she's unsafe at home. So she's voted with her feet. So now it's time for services to engage and try to support Ruby. Which I guess brings us to the next poll about accommodation. And this is another question that kind of pops up, but when can a young person rent their own place?
So when can I rent my own place? Sweet 16? I smell freedom 17? Come on, it has to be 18, or don't tell me. It depends again. What do you reckon, people? All right. Well, I think most of you, at least 50% of you have got it. It depends. But people who've answered 16 or 18, you've certainly got good reasons for those answers. So let's just unpack it a little bit. So basically, a child under 18 years of age may enter into an enforceable contract. as long as it's their benefit and as long as that they understand it, they're capable of understanding it. Now, people enter into contracts all the time. A 9-year-old who goes to the shop to buy lollies is entering into a contract by buying and selling. That's a very simple contract. It's basically, it doesn't involve any future obligations. It's pretty much the transactions done on the spot. A contract like an employment contract or renting property is different because it involves you signing up for obligations in the future that you're going to pay your rent and you get a benefit in return. You get to live there, and also the landlord has to keep it maintained and whatever. So, but you can still enter a residential tenancy agreement if you are under 18. Now, a lot of landlords are reluctant to rent to children under 18 because they think they can't enter an enforceable contract. Well, they can. So you can enter a contract when you're under 18. Now, the 16 age, where does that come from? That is actually a policy decision that has been made by Housing New South Wales, and I think also community housing organisations, that if you want to rent public housing or community housing, they generally draw a line in the sand and they say, we don't rent to young people under 16. But if you're 16 and over, yes, you can sign up to a tenancy, but the Housing New South Wales or the community housing organisations always ask the young person to get legal advice. They want a lawyer to have advised the client and to sign off that they've advised the young person on the lease and that they think they understand it. So that's where the sort of the 16 and the 18 comes from. Another thing that we should point out is there are a lot of landlords who won't rent to and real estate agents who won't rent to under 18s. That is age discrimination. I think, I should know this. Is age discrimination actually unlawful in New South Wales? There's different types of discrimination which are unlawful. It could be unlawful.
It is. I feel like I did one a few years ago, and I'm pretty sure I did it under New South Wales law.
Yeah, I think it is unlawful.
Federal legislation applies, yeah.
Yeah. Another thing that's unlawful is requiring a guarantor. So sometimes a landlord or real estate might say, sure, yeah, we'll rent you a flat, that's fine, but you have to get your parents, one of your parents, to sign as a guarantor. So if you default on the rent, they're going to pay. That is actually illegal. There is I can't remember the section of the Act. It's quite obscure. It's not in the Residential Tenancies Act, but there is actually legislation that says that's unlawful. Okay, so that's about it with renting. Back to Ruby, Kate.
Back to Ruby. So Ruby says that she's hoping to stay with a mate who lives in Parramatta. Ruby pulls out her phone, the screen is all cracked, and the speaker doesn't work. Ruby says she can send and receive messages, but she can't get calls, but it doesn't matter anyway because she has no phone credit. Ruby asks if you can help her contact her mate, tell her how to get to Parramatta. Ruby pulls out her wallet. She has around $5 in change. You ask if she has any ID. She says, nah, she thinks her mum has her ID. So we've got a couple of issues popping out here, which I think a lot of young people who have left home face. I guess the first one is around identification. And it's an important issue because to be able to access services, access income support, you do need ID. Getting a birth certificate is probably the primary document to try to get because one can get a birth certificate at any time. Then you've got other forms of ID. The next one would be a Medicare card. Ruby could get her own potentially at 15 years old. And then you've got the other ID there, tax file number 16, getting a passport. A bit more difficult if you are under 18 and you don't have your parents' consent. If you don't have, you need both. So if you've got two parents listed on birth certificate, you'll need both parents' consent. Otherwise, you would have to have a court order or get special permission from the Minister of Foreign Affairs. So that is can be tricky. I remember I did have a young person call up one time, and I think it was a school excursion to Japan or something, and I think one of her parents was deceased and the other, there was family violence, and she was staying at a friend's house, and she really wanted to go on the school excursion, so we were trying to get the special permission from the minister to allow it to happen. So it can pop up from time to time. But yes, the birth certificate, definitely primary document to try to access, and you can get a birth certificate using other forms of ID.
But if you've got no ID, and I'm sure most of you as youth workers would have experienced the frustration of trying to help a young person with this. If you've got no ID at all, it can be a bit challenging. You might have to get a bit creative.
Yeah, you do have to get a bit creative, like getting a letter from their GP or something from their school, or if they've been involved with the criminal justice system, using a court attendance notice, things like that. You do have to kind of get creative, thinking, where has this young person, or what services have they engaged in? How can I get forms of evidence to try to get that ID? Yeah. And the next thing about, I guess, Ruby, which kind of goes on to the next poll, is, I guess, getting some income support or payment. So that's our next poll, which is, when can I get a Centrelink payment? So if we launch that now, we'll find out, is it 18 if eligible for youth allowance? Is it 17? Unreasonable to live at home payment with youth allowance, is it 16? The unreasonable to live at home youth allowance, or is it all of the above? Getting some results now. Yep, so the majority say all of the above, and that is the correct answer. And some people say 16, which is also correct. So to be eligible for Centrelink youth allowance for young people, particularly who have left home, it would be the unreasonable to live at home payment, which is 16 and above. To get that payment, again, you'll need to have some forms of ID, which we just talked about. I did want to talk a little bit about crisis payments, though, because obviously Ruby is 15, so she wouldn't be eligible for that payment. And I brainstormed with some colleagues here about whether Ruby would be able to get some sort of crisis payment. My understanding is that crisis payments can be available, but it would have to be very exceptional circumstances. I'm not sure if Ruby would necessarily fit into those. And it would have to go through like a social worker at Centrelink. There'd have to be a lot of evidence around their circumstances to get some sort of payment under that age. And I think that goes back to, you know, Ruby, who's 15, because she is still in that young kind of age. The fallback would be looking at whether DCJ should get involved and pay for that support if there had been a history of risk of harm reports. So that's where I guess we come to there. Have you got anything else to add, Jane?
No, not at all. Yeah, okay. So back to Ruby. You asked Ruby if she was going to school in Wagga Wagga. Yeah, she doesn't like school that much, but she likes art class and music. You asked, does she want to go to school in Sydney? Ruby says maybe, but she might have other things going on. Ruby says she wants to see a lady doctor soon. She hasn't had her period in a couple of months. You ask, could she be pregnant? Ruby says, yeah, maybe. So another poll about when can I access my own health care. So first answer, it's probably 15 when I can get my own Medicare card. Or what about 14? Maybe it's even younger, 12. Or again, I guess it depends. Okay. Quite a spread of answers there, but again, the majority have said it depends, which is the correct answer yet again. If we go to the next slide, we'll get into a bit more detail about why it depends and what does it depend on. So, some of you might have heard about the idea of Gillick competence or a mature minor. So the name Gillick comes from a case from the UK where a mum who had some teenage daughters complained about, I think she sued the local health authority because she didn't want them giving out contraceptive advice or any kind of reproductive health treatment to her teenage girls without her consent. And the court said, sorry, Mrs. Gillick, but as you grow up as an adolescent, your independence grows with gradually with your growing maturity, and parental control dwindles. And so a child who is old enough, mature enough to understand the nature and the consequences of any proposed medical treatment can consent to that in their own right without parental consent. Now, there are some exceptions to that, but we'll get onto that in the next slide. Now, usually that age of Gillick competence for most forms of treatment is thought to be about 14, and that's often the age at which medical practitioners will deem a young person to be competent. But it could be younger or it could be older, depending on the individual young person and the nature of the treatment. So next slide. Okay, so there is a law, it's in the Minors Property and Contracts Act, and it basically says if you're a doctor or a dentist and you perform treatment on a child, then it protects you from being sued for assault and battery. So if you do any kind of invasive treatment or even a medical examination where you touch someone, if it's done without consent, then that's an assault and battery. Now, that law basically just covers doctors and dentists from liability if the child is 14 or over. If the child consents, that's fine. Or if the child's aged under 16, so 15 or under, the parent consents, that's fine. That protects doctors and dentists from being sued for things like assault. Now, that is not exactly the same as saying a child is competent to consent at the age of 14. Any medical practitioner needs to, or healthcare provider needs to assess whether this individual young person is competent, whether they think they're competent to consent. Now, if the healthcare provider has got reservations about whether the young person's got capacity to consent, then they may need to seek parental consent. And if Ruby says, no way in the world, you are not contacting my mum over my dead body, then there may need to be an application for a court order. I think if you're under 16, it has to be a court. It's a little bit complex who you go to, but it may be the family court. If you're 16 or over, then it's NCAP in the guardianship division. So it is a bit complicated, but the main message here is once a child is mature enough to understand the nature and consequences of the treatment, then they can consent in their own right without parental consent. Can we just have, I think there's one more slide on this as well. And it does include most types of sexual and reproductive health care. So anything pregnancy related. If Ruby turns out to be pregnant and she doesn't want to keep the baby, she can have a termination as long as she's capable of consenting. It doesn't have to go back to mum for that. There are some treatments though, like sterilisation or certain kind of gender affirming treatment, which might require a court order. Okay.
Okay, Ruby. Now Rick. So Ruby comes back to see you and says to call them Rick from now on, like Rickroll, you know. Rick says they want to change their name legally to Rick. They don't want their mum finding them. Mum doesn't understand any of the pronoun stuff or that you could be non-binary. Rick wants to go to art school and has found a school they like. Rick asks for your help to enroll. So we've got a couple of new issues here now. I guess the first one is about changing your name. So if we move to the next slide, when can I change my name? So at 18 years, you can legally change your name. If you are under 18, you've got two options. You can just do it informally by asking people to call you by your preferred or chosen name. That doesn't require any forms to be filled out. But if you want to get your name on your birth certificate change, if you want it to legally change your name, you do still require both your parents' permission, unless there's only one parent named on your birth certificate, or if one of your parents has died, or if there is, again, a court order that says it's in your best interests. So when I've had calls from young people or spoken to young people about this, particularly if they're 17, I usually advise just wait until you're 18, because by the time you're going to, go through a court process, it's going to be time anyway, and it's going to be much easier to change your name once you're 18, because it's just about filling in a form, paying a fee. If you try to do it before, it has been done. But it does involve going to court, and as we all know, court cases can take a long time. But yes, it definitely has been done at least once that we know of, where a young person has changed their name without either parent's consent. But that was very exceptional circumstances where there was family violence and other exceptional circumstances going on. But yes, but Rick can be called Rick by services, by saying that they now should be known as Rick. The other issue there was that Rick said that they wanted to go to school and they wanted help enrolling. But first, let's talk about when young people can leave school. In New South Wales, the leaving school age is 17. So the law says that young people need to be in education until they are 17. Or if they're finished year 10. But if they have not turned 17 yet after finishing year 10, they still need to do some other kind of training or be in full-time work or do a combination. Yes. But what Rick was asking about, which was enrolling, so maybe if we move to the next slide, because generally you would need your parents' permission to enroll in a school, but we know that the Department of Education recognises that there are young people out there who are living independently, and so they need to work with them to fulfil their education wishes. And I think that there is a recognition that as young people become older, they're able to make their own decisions, but it's really going to be a case-by-case basis. The young person talking to the principal, maybe with their caseworkers, their youth workers involved. The schools can liaise with an alternative responsible adult or the young person directly. It is going to be, again, a case-by-case basis. I think we've had calls, I'm sure you've had calls before, Jane, about young people wanting to go on excursions and needing excursion slips signed by a parent before they're allowed to go. There is again, like a form, if they were staying with like another family member or a family friend, a form that that family member or friend can fill out saying that they are taking care of the young person and can agree to those excursions, etc.
But also at a certain age, a young person can just consent in their own right. So there's, I think, a lot of misconceptions around this. There is no law that says that a young person can't go, to visit the museum or horse riding or whatever it is without parental consent. A young person could do that at any age. This is really just the school trying to protect themselves from liability if a kid falls off a horse or runs amok in the museum or whatever. They're trying to protect themselves from liability. They're trying to also, protect themselves from being sued by the parents. Well, I didn't consent to Julia going horse riding and now she's fallen off a horse and we're going to sue you. So they're trying to make sure that whoever is responsible for the child understands the risks involved and, what is involved and agrees for that to happen. Or it might be going to the museum where, oh, my shock horror, we're from Florida and we're going to see the statue of David, and parents might not want that. How dare you expose my children to such obscene material? So, yeah, it's about parents being informed of and schools protecting themselves from liability. But, where you do have a child who is, I would say, 15, 16, 17, so probably year 10, 11, 12, if they don't have a parent or a guardian or responsible adult who can sign those slips, the Department of Education policy says that really it's about trying to facilitate young people's participation as much as possible. So if there isn't an adult to sign that, then the young person, if they're competent to understand, should be able to consent in their own right.
Yes, that's right. Definitely. I think if a young person, particularly at that age, wants to be in education and is being proactive, and then the department should really be supporting them, and what's in their best interests is really paramount. I mean, there may be situations where parents are saying no to, well, let's say for Rick, saying no to enrolling in this new art school, but I think it would just come down to the school and the principal discussing it with Rick and whoever Rick's supports are at the time. And again, if it's in Rick's best interest to go to that art school, then that really should happen. And young people can get legal advice, and lawyers can assist with any complaints or negotiations if there are difficulties there. But yeah, great. Well, that's the end of our kind of formal presentation. So happy to take questions. Do want to flag some resources, and the first one, which is the legal information for youth workers, developed by Jane at the Shopfront Youth Legal Centre. These are a range of fact sheets, and thank you, Jane. They've been so valuable resources for many lawyers, many youth workers, and thank you so much for keeping them up to date when you can. But that is a great.
Oh, we really try. Most of those fact sheets you will actually see are about police and criminal law and stuff, traffic and whatever, fines, because that's what we do a lot of. But the ones towards the bottom are probably the ones that you'll find a little bit more useful. There's stuff about children and healthcare. There's one about the age of consent, so sexual consent, which we haven't really spoken about today, but if you've got any questions about that, we can probably answer. There's something about child protection and reporting of children at risk. So yeah, the ones towards the bottom of that page are probably going to be the most useful. And then Legal Aid, of course, also has great fact sheets and resources, including there's a When Can I page. Kate, do you want to talk a bit more about that?
I'm not sure if we've actually got that made to the public. I'm not.
Okay.
Maybe Bridget would know, but yeah, not sure if you know Bridget. But
I'm pretty sure that is on the Legal Aid internet. So yes, under what we do, workshops and webinars, there's a section on youth resources, and I'm pretty sure that the When Can I resources are available there. I will double check that and provide a link in the email that everyone will receive after today's webinar, so that they can find that information easily.
yeah. And Youth Law Australia is also a valuable resource, has lots of information and targeted for young people in particular. So if you do have interested young people, you can always direct them there because it's very easy to read and absorb.
And also got information about other states other than New South Wales. So that's helpful too.
Yeah. Especially
if you are like Rick from Wagga Wagga or, Albury Wodonga. One of our participants I know is from Tallangatta, which is very near the border as far as I can remember too. So if you are in those sort of border regions and work with young people from interstate, then Youth Law Australia is helpful there.
Great. So we do have a couple of questions that have come in during the webinar. The first one, I'm pretty sure came in during the discussion about consent to medical and health treatment. Is one parent consenting okay, or do you need both if there are two caregivers?
So I'm happy to have a go at this. This is in most situations, I think one parent consenting is okay. I mean, your kind of most common situation, which happens every day, is a kid has a cold, or they've, fallen over, they've had an injury on the footy field or something, and one of the parents takes them down to the GP. Now it can be either parent, as long as that that parent has legal parental responsibility. Consent of one parent is fine. That's obviously for a child who's too young to give their own consent. If it was somebody if it was a termination of pregnancy, that's a more significant procedure. Again, consent of one parent is usually okay, but for things like that, which may be a bit more controversial, you may have one parent objecting. So, you may have mum who says, yeah, I'm fine for, my daughter to get a termination, and dad says, no way, this goes against our religious beliefs and she's going to keep the baby and blah, blah, blah. And I will not allow. So where you have a dispute between parents, then that would probably have to go off to a court or tribunal to be resolved. For some kinds of treatments, so such as gender affirming treatment. So if it's really complex actually, but basically I think stage 1, stage 2 or stage 3, so puberty blockers being stage 1, hormones being stage 2, and then surgery being stage 3. For those kinds of treatments, because they are quite significant, I think that the law is now requiring the young person to be GILIC competent and consent of both parents, or at least consent of one parent and no objection from the other. So yeah, I suppose the more complicated the treatment is, the more likely you're going to need consent of both. But for most things, just one is okay. That's a long answer, sorry, but I hope that explains things.
Thanks, Jane. I had a question about the GILIC competence. I just wondered, does a doctor have to make a formal record of having assessed competence in their notes?
I think they should. Yeah, I would say. I mean, that's good practice to make proper case notes. I, as a lawyer, if I have concerns about a client's capacity to give me instructions, I would make notes about that. And if I decided that they do have capacity, I would sort of explain why. So yeah, I think they would have to. I mean, unless it's obvious. I suppose if they're like 16 or something, and it's fairly obvious if they're sort of above the age where generally a young person would be regarded as GILIC competence, then maybe not. But if they're around 14, 15 or even younger, yeah, I think the doctor should be making notes.
Thanks, Jane. The next question we have is, at what age can a young person get legal advice?
Well, let's see. I think the youngest I've given is 12, but we know that children as young as 10 can be charged with criminal offences, and so a 10-year-old would need legal advice.
But also we give legal advice on a whole range of other issues as well. So we have sometimes children referred to us by the DPP when they're witnesses in criminal trials. So sometimes maybe, you know, mum or dad has been charged with an offence and the child is a witness. And we've advised kids very, very young, like as young as 7. And that's kind of quite challenging, but there's no lower age. So
would you have the parent or guardian there as well? Or
not the parent, absolutely no way, because the parent's involved in the criminal proceedings, so there would be a conflict there. But we'd usually try to have a support person there, you know, somebody who's independent of the proceedings. And we'd sort of have to try to assess whether we thought that child was competent to give evidence, because if you're going to be a witness in court, in order to give sworn evidence, which is, you know, making an oath or an affirmation to tell the truth, you have to be competent to do that. You have to understand the difference between a truth and a lie, and that you can get into trouble for telling lies in court. So often in providing legal advice to children that young, you know, we're also making an assessment of their capacity, and we might feed that back to the court. You know, if we have doubts that the child's competent to give evidence. But yeah, I think no longer age.
Yeah.
The next question is, for a 17-year-old signing a lease, are you able to provide legal assistance to them in signing the lease?
I've definitely gone over the tenancy agreement with 17-year-olds, and I guess, given them that advice, which is what's required for New South Wales housing. So yes, if that's the assistance that they are requiring.
We do that too at the Shopfront. We're a service for homeless young people. So generally, if a young person's wanting to sign a lease, you know, at 16 or 17, they've often come from a background of homelessness. So yeah, we would normally do that too.
Another question is whether psychologists are covered by GILIC competence.
I think so. It's a bit of a grey area, because most of the law about medical treatment, it talks about medical treatment, and it kind of assumes that the treatment is going to be like physically invasive or involve, you know, touching the body, which would otherwise be an assault, or maybe involves administering of drugs of some sort, which, you know, obviously can have an effect. But if it's a psychologist doing psychotherapy, that's a slightly different considerations. But yes, I think the general principles are the same. If you're a psychologist or a counsellor, you would want to, you know, to establish a therapeutic relationship with a young person, you would want to satisfy yourself that they have the capacity to consent to the sessions and to forming a therapeutic relationship, and also to understand the concept of confidentiality. So consent to treatment and confidentiality are slightly different things, but they do go hand in hand often. Now, obviously, school psychologists see kids who are very, very young, you know, young children with behavioural issues, or there may be family, you know, family counselling going on, or family court might be set to family court counsellors or whatever. So clearly very, very young kids get sent to see psychologists, and they're generally there, you know, at the behest of their parents, or, you know, with a court order or a referral from some sort of agency. But I think, if you were going to try to establish an independent therapeutic relationship with a young person where that was confidential, so you saw the young person independently of their parents and didn't report back to the parents, then I think the GILIC competence test would apply.
There's a question about tax file number. Sandy has a 13-year-old living with an 18-year-old sister. can the 13-year-old obtain a tax file number for a Centrelink claim?
I wonder if the question's asking whether, so was the sister 18?
Yes.
Wanting to get payment because she's caring for the 13-year-old.
That's what it sounds like, yes.
Yeah. I don't know off the top of my head. So
yeah, I'm wondering about because I think in the slides it said 16 to get a tax file number, but I'm pretty sure
well, yeah, to get a tax file number.
that my 15-year-old has gotten a tax file number when he got a job recently. So it might be possible. It's probably worth just applying and seeing.
But if it was, if you've got a 13-year-old living with the 18-year-old sister, I think it wouldn't be the 13-year-old claiming benefits. It would be the 18-year-old claiming a carer's, like a carer's allowance for caring for the 13-year-old. So the 13-year-old probably wouldn't need their own tax file number.
That's right.
Another question is, how would you assess a child's capacity as a lawyer? Is there a particular framework that you follow?
Good question. Is there a framework? Well, I guess it depends. It depends on, how they present, their maturity. Obviously, if they've got any disabilities, we want to take that into account. I don't think there's any kind of framework. I would say it's just whether you feel like they can give you instructions. So if they can explain, what they want and what's happening, that's kind of just how I go with it. Obviously, if I feel they're not understanding, whether it's due to disabilities or whether, obviously can't really take instructions or advise if someone is under the influence, but I think you just make that assessment per conversation and per client. Would you say so, Jane, or have you got a different?
Yeah, I don't so much have a framework or a formula, but some things are important, and I think people who work with young people would mostly understand this anyway. An obvious one is not just to ask, do you understand that? Because they'll say, yeah. Can you explain back to me what I've just said, or what do you understand by this? What do you understand your options are? So, if they can explain it back to you, that's a good sign. Kate mentioned things like being under the influence. So obviously people's cognitive functioning can vary over time due to factors like stress, being intoxicated, being mentally ill, and other factors. So I guess if you had concerns about someone's capacity, you would probably want to, and I know that this is a luxury and it's not a luxury we all have, and that's time. If you are actually able to speak to the young person, on different occasions over a period of time, so that you can get a sense of whether, maybe they're temporarily impaired in some way, or whether this is a kind of, more long-term thing. Consulting other people. So, are there other experts who've been involved? Has the child been diagnosed as having a cognitive impairment? Are there other youth workers that work with them, and what do they think? And I'd need to make my own independent assessment of the young person, but I would maybe take some advice from other professionals. An important thing, of course, is that just because someone wants to, make a decision that's not in their best interest doesn't mean they lack capacity. So the classic one is for kids, in that this is a criminal scenario, but kids in the children's court, I want to plead guilty and get it over and over with. But you're not guilty. They can't prove the case. Oh, but I want to. And what they actually want is they just want to get rid of their curfew, because they're on bail with a curfew condition and they cannot stand it. And if we say, okay, what if we could get your bail varied and get rid of that curfew? Would you then like to defend the charge? Oh, miss, okay, fine. So sometimes you think, that wanting to make a really rash decision without regard to the consequences. I think if you can sort of unpack what's operating on a young person's mind, you're often going to get a much a better quality decision and also a better idea of whether they've actually got capacity.
Thank you. They're all the questions that we have. I just wanted to check with both of you the best way for people to refer young people to your services.
Okay. I can speak about the Shopfront first. Probably the best way, well, there's two ways, but probably the most common way would be just pick up the phone and call our office, 93224808. Don't worry if you can't write that down, it's on our website. If you call us sort of 9 to 5, Monday to Friday, you'll usually get someone answering the call. It could be one of our students, mostly law students who are our volleys. It might be one of our other staff. It might even be one of our lawyers, but someone will pick up the phone, get you to give us as much information as you can. And bear in mind that we're a service mostly for young people who are homeless. We can kind of bend things a bit around the edges, but it's mostly young people who are homeless or at risk of homelessness that we advise. We like to get referrals from youth workers and service providers. We find those referrals are really good. A young person can self-refer if they want. We don't take referrals from parents though. I mean, sometimes if a young person we're working with has supportive parents, that's great, but we can't take referrals from parents. So just a phone call is fine. You may not have all the information we want, but you just give us as much as you can. If it's something quite simple, we may be able to give you advice straight away or, quite soon. If it's a little bit more complex, then we may need to take it to a staff meeting and get back to you. You can also email referrals to us. We've just got a general Shopfront inbox. You can send stuff by email. Okay, Kate.
And for our service, we're quite a specialised service within Legal Aid, and we only work with young people who are in the criminal justice system or who have had history with the criminal justice system. So we only take referrals from the Aboriginal Legal Service, the Shopfront Youth Legal Service, and Legal Aid's Children's Legal Service. Sometimes we take referrals from Youth Justice as well. And at this time, we only really can help young people who are living in Sydney, Greater Sydney. However, if you do have young people who need assistance, I would suggest contacting your local legal aid office, contacting your local community legal centre, because a lot of those questions and assistance can be done with by a lawyer from one of those services very, very easily. Our service is quite specialised, and it's very tricky to get into our service, but there are many, many other legal services, free legal services that can help young people around the state.
Thank you both. And I'd just like to let our participants know that I have uploaded a copy of the presentation into the chat, and we'll also send that out in the email following today's webinar. And if any questions occur to you after the webinar, you can send those to clewebinars@legalaid.nsw.gov.au. I'd like to thank Kate and Jane for a great presentation, and please feel free to look at our calendar online for further webinars coming up. And thank you for joining us today.
Thank you, Bridget. Thank you, everyone.
Thanks, everybody. Thanks, Bridget, for organising.
Yeah.
Thanks very much. Thanks, everybody.
Thanks all.
Bye.